Okay, I think we can start. So welcome to the audience here at the Geneva Press Club. My name is Pierre Rochi. I'm the director of the Geneva Press Club, Club Suisse de la Presse. And it's a pleasure to see you here. And I also want to welcome all those speakers and some media and public that is following us on Zoom and that will intervene directly from anywhere they are. And finally, welcome to all the people following us on our website, www.pressclub.ch, where this session is live streamed and will be set on our internet site, and you will be able to find back this session on the site. So it's a pleasure for me. I welcome our speakers here. As I said, we will have a session, as we call hybrid session, people here speaking, people on Zoom speaking from sometimes remote places. So it's often interesting to have people a little bit from everywhere and to bring them together. This way is easier and makes it pretty interesting, actually. So I thank you very much. And without taking more time for this introduction, I will give the floor to Mr. Ronald Barnes, who will moderate this panel. Thank you for coming, organizing this with us. You are at the head and the chair of the Indigenous People and the Nations Coalition from Alaska, and very active here in Geneva for many, many years. So, Mr. Barnes, I give you the word.
Okay, thank you, Mr. Rochi. Thank you for the introduction. I would like to open by saying I'm from Alaska. I represent the Indigenous Peoples and Nations Coalition, which is the free political institution from Alaska and designated so by the majority of tribal governments from Alaska. I was appointed as the permanent representative from Alaska. Alaska was listed under Article 73 under General Assembly Resolution 66I in 1946. And so we were on the list at the same time that Morocco, Tunisia, Indonesia, and other non-self-governing territories were placed on the list. So when we were removed in 1959 under General Assembly Resolution 1469, the United States of America did not follow procedure. The African states, during the process of adoption, accused the European states and the United States of democratic despotism. They questioned many of the GA resolutions, saying, well, what about General Assembly Resolution 742? And what about this other resolution where we have to examine this procedure and monitor this? And so there were many questions during the adoption. And when we discovered this in 1982, the state of Alaska tabled a report called the 1982 Alaska Statehood Commission Report. In this report, it stated that Alaska still has a right of independence, or we could choose a compact of free association, or we could develop some other level of relationship with the United States of America. So as we introduce this panel, it's about consultation on double standards in human rights towards cooperation and improving relations. The experts from the former subcommission made it very clear to me. There were two of them especially, and the former expert from Greece, Erica Irene Dias, and of course the late Miguel Alfonso Martinez, were very strong in asserting, as Erica would say, ambassador, you always assert your status and never, ever let any other state reduce you, or the possibility that you have the right to represent Alaska as a permanent representative. You are a UN Charter state-based ambassador. Why? The reason is because when they followed procedure in our case, we never decided anything. And when you look at what happened in Algeria or Tunisia or Morocco, when the French people voted, the General Assembly said, no, 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 that is not a province of France. The French people cannot vote. Only the Tunisians in Tunisia, only the Moroccans in Morocco, and perhaps Mr. Alfred Desires will elaborate on this point of law, why the peoples concerned under Article 73 are the ones who determine the status. Being that Alaska, the indigenous peoples of Alaska did not determine the status, we assert our right under international law in no uncertain terms that we are a state of peoples and we have sovereign equality under Article 1.2 of the Charter, the equal right and self-determination principle. So this goes back to this consultation on double standards in human rights. If the European states were accused by the African states of democratic despotism, and they went further, they said, Alaska and Hawaii is nothing but a gift to United States of America. Since you're just granting this to them without following procedure as a gift, since you freed them from the Axis powers after World War II under the Hitler regime. So we assert unequivocally, and we use Indigenous Peoples and Nations Coalition. When you look at the case of Palestine, it came in as an NGO and it developed into representation as a state of peoples with a seat in the General Assembly. So one of the experts of the subcommission said unequivocally, said Alaska and Hawaii cases are so strong, they have a right, like Palestine, to have a seat in the United Nations equal to any other state, even if we sat it as an observer as we were attempting to resolve our unresolved case where we are recognized as a state of peoples under international law. So I believe for the audience throughout the United States, in Europe and Canada, Alaska, Hawaii, and elsewhere, I'm going to read the first paragraph to give you an idea the importance of what we're trying to do here today. And that is to address double standards in addressing human rights here at the Human Rights Council, and also reports that are sent to the General Assembly, the reports that we give and to the special procedures, advising them so that they can properly record our testimony, give conclusions and give recommendations so that our peoples can get a recommendation to address the violation of our human rights. So in an ideal world, human rights and international law would be applied uniformly. States would understand human rights as a holistic system of law. Civil society and non-governmental community would have more space. The politicization of human rights with the double standards would exist in the work of the Human Rights Council and in other UN bodies. This allows for states to enjoy virtual impunity for multiple crimes in ongoing exploitation of peoples and territories, revealing a credibility gap. We have witnessed a well-orchestrated naming and shaming of countries by the South, by the North, and the former colonial and occupying powers. The legacy of colonialism and the adverse impacts on the economies and infrastructures of developing countries are perpetuated by puppet machineries that remain in place to serve the economic and political interests of the former masters. So how can we contribute to the recognition of our common human dignity as the source of all human rights, which should be promoted and protected equally without discrimination or privilege? And we introduce this because we would like to make things better, not only for Alaska, for other peoples, for peoples who are coming here from various parts of the world who would like to have their violation of their human rights recognized, those who suffer from extrajudicial killings, who are in other parts of the world, the migrants. We want not only Western states to promote and protect human rights, we want all states. And it should not be that Western states go after undeveloped states or the poorer states. They should go after also the states that are committing these serious human rights violations, going into other countries, taking their resources, their oil, placing puppet regimes, etc. So with that, I'm going to read the second and the third paragraph of the introduction in between speakers so that I give the chance for our distinguished Professor Alfred Rochi to open up on his topic. Of course, Professor Rochi, I've known him for many years. He's not only a good friend, but he is a current professor of international law at the Geneva School of Diplomacy. And I could see some of his students in here attending. And he's retired from the Office of the High Commissioner for Human Rights. And Professor Rochi has served as the first UN independent expert on the promotion of a democratic and equitable international order from 2012 to 2018. Of course, you can only serve for 6 years. Although retired, he continues to lecture and to promote human rights for everyone. So I present to you Professor Alfred Rochi.
Thank you, Ronald. Friends, colleagues, I see many faces that I recognize in the room. And what I'm going to say is nothing extraordinary. It's something that basically everyone has thought about. And it's the issue of the credibility, the authority of the United Nations, of the Human Rights Council, of the Organization for the Prohibition of Chemical Weapons, etc. That really stands and falls on objectivity, on rigorous application of that principle, both of general law and of history research, audiatur et altera pars, meaning you have to listen to all sides. You have to study all views before you make a judgment. And in today's world, our problem, or one of the many problems we face, is access to information and how, through algorithms and otherwise, the information that reaches the citizen is very frequently filtered, is skewed. And that I can say from my own experience, doing research, I have found that even United Nations documents that are in the internet, that should be easily accessible, if they are problematic, you won't find them. I mean, there is, just to name one example, Navi Pillay was the High Commissioner for Human Rights back in 2012. She did a fantastic report on unilateral coercive measures. Try to find it. It's HRC 19 bar 33, but I'm sure that there are algorithms that are blocking access to that document, as there are to the ECWAS report by Professor Richard Falk and Virginia Tilley on the impact of sanctions in Syria. These things are abnormal, but you cannot function unless you have solid information. And more we see evidence-free allegations being picked up by the New York Times, by the Washington Post, by CNN, and everybody just repeating it so often that the fake news as it becomes plausible. And fake news, of course, generates fake history and fake law just by politicians who want something to be legal. They simply postulate it. They make a reference to some resolution of the General Assembly, and suddenly it is supposed to be hard law, supposed to be binding. Well, that's not the case, but with the complicity of the mainstream media, they get away with it. Now, Ron just mentioned Resolution 1469. That's a resolution that freed the United States from reporting under Chapter 11 of the United Nations Charter, reporting on the advancement toward self-determination of Alaska and Hawaii. Of course, the referenda held in 1958 were just fraudulent because the only people who had a right to participate in the self-determination referendum were, of course, the natives, not the American army stationed in Alaska or in Hawaii. And they all voted. Matter of fact, they were persuaded to vote. They were paid to vote, whereas the indigenous were intimidated in not voting. And many of them were disqualified because they didn't speak perfect English. So the whole thing is fundamentally flawed. And of course, it can be challenged. You will remember the infamous Zionism is racism resolution of 1970 that was done away with by the General Assembly by another resolution in 1991. So it is entirely possible to revisit a resolution of the General Assembly and to change it. But now let's get to certain examples of double standards. In my 41 years of working in the United Nations in various capacities, I was hired by the great Theo van Boven, with whom, by the way, I still have quite a bit of contact. Theo van Boven, professor at the University of Maastricht. He was the director of the then Division of Human Rights. He hired me in 1980. And that was a time when we really were a very small office and people were excited about what we were doing. I mean, we were convinced that we were going to make a difference. And at that time, you didn't have the politicization of human rights or the weaponization of human rights as you have today. And I've seen it over the last 40 years getting increasingly political, increasingly one-sided, and the selectivity of the Commission on Human Rights, of the Human Rights Council, of the UPR, et cetera, is shocking. And of course, it goes at the expense of the authority and credibility of the entire system. Now, one example, whereas, you know, countries get condemned all the time, naming and shaming. There are resolutions adopted against Venezuela every other day, et cetera, or against Belarus. Now, take the Commission on Human Rights back in 2003. Everybody knows the horrors of Guantanamo. Everybody knows that torture was systematically practiced in Guantanamo. People were subjected to arbitrary detention. The Working Group on Arbitrary Detention made several findings on that. Well, when it came to the Commission on Human Rights, the predecessor of the Human Rights Council, the Europeans actually succeeded in blocking the resolution by adopting an earlier resolution, what you call a no action resolution. So you actually decide not to vote on the resolution. So they killed it in 2003. When it came in 2004, they killed it again. So you see how really irresponsible the Commission on Human Rights could be. And if you think that the Human Rights Council is any better, well, my personal experience as a as independent expert on the promotion of a democratic and equitable international order, is that there are independent experts and there are independent experts. That is, there are some experts like Niels Meltzer, who just published a fantastic book on Julian Assange. At present only exists in German. The original version, Der Fall Julian Assange, published by Pieper in Munich, one of the biggest publishers in Germany. I'm very, very happy that Pieper took it, because the book is really breathtaking. It's, you talk about the Dreyfus affair, and you talk about Emile Zola, and you talk about J'accuse. What Niels Meltzer is showing us is many, many times worse than what happened to Alfred Dreyfus in 1898. And thank God there was an Emile Zola, and thank God there is a Niels Meltzer. But what Niels Meltzer shows is the corruption, the undermining of the rule of law, not only in the United States, but in the United States, United Kingdom, Sweden, Ecuador, the collusion of these states in what is termed lawfare to destroy Julian Assange. And the same countries that are destroying Julian Assange, his detention or his situation was declared to be arbitrary detention under Article 9 of the Covenant on Civil and Political Rights. That was the judgment of the working group on arbitrary detention back in 2015 in December. And then in January 2016, I issued a press release telling the UK and Sweden, for heaven's sake, I mean, you're always pointing fingers at others. You know, when the United Nations body finds that you have violated human rights, I mean, give the good example to the world and release this man. Of course, at the time, David Cameron called it ridiculous, this demand, et cetera, et cetera. I mean, the arrogance is really breathtaking. And it's not only the arrogance, it's the rank hypocrisy that I observed over the last 41 years. Now, Ben Emerson, the special rapporteur on human rights while combating terrorism, he issued a report in 2013, which outlined the horrors of the policy of extraordinary rendition. These were the kidnappings of individuals who, without any due process, without anything, were just simply handed over to the CIA for purpose of torture. They were sent to secret camps. They were sent, sometimes kept in ships, so that they could have no access to press or no access to lawyers, no access to anybody. In any event, they disappeared there for a while. I remember one of the victims of this extraordinary rendition was Maher Arar, a Syrian who was living in Montreal. And at that time, when I was professor, I had taken early retirement from the UN, and I was the Douglas Mackay Brown Chair in International Law at the University of British Columbia in Vancouver. And it was so horrendous that I organized the faculty to demand the Parliament in Ottawa to investigate Canada's involvement, because of course Canada gave the name to the CIA. That's how come the CIA could get them. And how did Canada, get the name? Because he happened to have been at a party where there were many other Muslims. And well, fine. The same thing happened in the Sayadi case, Belgium, a case we had before the Human Rights Committee when I was still with the Human Rights Committee. And that was a very interesting case because this individual, Sayadi, he had his bank accounts frozen, and he had his passport confiscated, et cetera, et cetera, et cetera. He was ruined as a businessman. And he said, but how did I land on this sanctions list? and Belgium came to us and said, oh, no. I mean, Human Rights Committee has no jurisdiction because, I mean, we are just following the Security Council, except that we had very good people in the Human Rights Committee at the time, including Yuji Iwasawa, who is now the Japanese judge in the International Court of Justice, and the late good friend of mine, Sir Nigel Rodley. And they both essentially argued, look, you know, the Human Rights Committee very much has jurisdiction because you made a mistake. You put them on the list. So it's not that you're following the sanctions of the Security Council. I mean, you put them in the list, and that was reckless endangerment for this individual and his family. And as a matter of fact, we even invoked Article 24 of the UN Charter. I always say the UN Charter is the world constitution. And Article 25 says, of course, that decisions of the Security Council are binding. But Article 25 follows Article 24. And Article 24 sets out the terms of reference of the Security Council. The Security Council is not above the law. The Security Council cannot act in a manner inconsistent with the object and purpose of the UN Charter, inconsistent with the purposes and principles of the organization. So it was really extraordinary that we could, in the Human Rights Committee, invoke Article 24. So there is flexibility, and that's why I'm saying 1469 will fall. We will make sure that 1469 is removed. Now, I'll give you a couple more examples. Now, yes.
One more example.
Go to the next. No, afterwards, I can talk for hours, as my students know. I don't even give them a pause in class. I just keep talking. As the case may be, everybody's talking about this poor fellow, the blogger Roman Protasevich, now the Belarusian blogger. Well, of course, it's massive violation of international law to claim that there's a bomb in a plane and have the plane land in Minsk just to be able to arrest this blogger. Certainly a major violation of international law. But again, you have to put things into context. What the Europeans did in 2013 with Evo Morales, the head of state, the president of Bolivia, to force his plane down in Vienna because they wanted to search the plane with full sovereign immunity. I mean, it's amazing that they would do that. They searched the plane, and of course, Edward Snowden was not in. But everybody just forgets what happened, and that's not. There were several other cases also involving Ukraine. The Ukraine, for instance, had a plane that was going to Minsk, to Belarus, had to come back. That was 2 or 3 years ago. And do you think that the New York Times, the Washington Post were upset about the fact that they basically hijacked the plane and had it land in Kiev in order to arrest a political opponent? No. So here is classical double standards. And the last one is, of course, Navalny. It's amazing what unisono you get from the New York Times, Washington Post, CNN, and of course, Germany, Deutsche Welle, Frankfurt Allgemeine Zeitung, concerning Navalny. Of course, we all want to see Navalny liberated. Of course, we're against his arrest. But what has happened to Assange is 1,000 times worse than what has happened to Navalny, and the world tolerates it. The Human Rights Council tolerates it. So if you apply international law a la carte, you are actually undermining yourself. You're undermining your authority, and you're giving the bad example. because if the big boys commit gross violations of human rights, what can you expect of the little ones? What can you expect of countries in Asia or Africa, etc.? There is a saying in Latin, quod licet Jovi, non licet bovi, which means that which is allowed to the god Jupiter is certainly not allowed to the bovi, to the bovines, to the bulls. Thank you.
Thank you very much, Alfred. Of course, you always give a lively speech, and you mentioned that there are other cases where either the former Commission on Human Rights or there were other incidents where other states engaged in activity that was clearly a violation of international law, but nobody said anything. And it goes, as you would say, the plane lands and is taken down with the president of a foreign country. And each country is supposed to have sovereign equality. So where is the sovereign equality and who has the power? So power does say something in today's world.
And the media.
And the media, yes.
The media is complicit.
And the media is also complicit in this, because when you look at the Western media or the so-called state media of the communists, and they always used to have tit for tats. When you look at the nitty-gritty, it's not much different. There are violations on both sides. So let me go on. I will start with Alice Abu. She will give you her traditional name. She's a 7-year residential school survivor from Sekwem Pemkul of the region of Kamloops, the unceded territory in the interior of the so-called British Columbia, Canada. Ms. Abu is KE 70 academic, a land defender, a water protector, dedicating the majority of her life, she's not afraid to say she's 68 years old, to the sacred inherent rights of our lands, waters for the next 7 generations. She works extensively for the betterment of our indigenous peoples and is a lifetime advocate for human rights and looks forward to continuing this important work. Now, just to give you a briefing, what happened recently was the discovery of over 200 children's bodies at a residential school that they unearthed. And so this residential school system, there are many places where many children died, but I will let Madam Abu give you her account. Thank you.
You're uploading the video?
Wait, wait up. In Jesuit, is het schwappen. Doch nog nachen. De galmoch squast. Iganawaki. Alice Abbey is my colonial name. I am from the Sisquapan Uluk. I attended the Sugarcane Indian Day School for 2 years. I'm a survivor of St. Joseph's Mission Indian Residential School, established in 1867. One day when my father came over to my mom's house, I was 9 years old. He asked my mom how come I wasn't in school, and that the Indian agent, Mr. Christie, told him that if I didn't go to school, white people would take me and she wouldn't see me anymore. Not go to school at the Indian Residential School. So my dad took me over to St. Joseph's Mission. It was a really big white building. The nuns came and took me upstairs to the 3rd floor. They took all my clothes off, took me to the washroom, the bathroom, and then they cut my hair and they put DDT in my head. And then they took me over to the big room where there's lots of showers. And they washed me. Then they brought me over to my bed and told me that this was my bed, that my number was 45. There was no names. My number was 45. They gave me their clothes and their shoes. If I disobeyed, there was punishment and there was hell. At nights, for the longest time, I was really afraid. I was really scared. There was just so much fear instilled in me that at night I would crawl under all of those beds to my sister's bed. She was a junior then. And I would ask her to please don't sleep before me. And I'd fall asleep with her. In the morning, Sister Juliet would come and she'd have her cowbell and her whistle or her stick. And she would just put on all the lights. And we'd hear all of this noise, and she'd come over to my sister's bed and she'd start hitting my sister, and she'd hit her with the cowbell sometimes because I wasn't allowed to be in her bed. From being hit so many times and my hair pulled, my right ear, it started to leak. There was some liquid coming out of my ear, and Sister Joseph took me up to the sewing room. And she put my head sideways with my hair, and she took this bottle and she's pouring it in my ear, and it was really cold, and it was pure rubbing alcohol. I could taste it, and it just burned. And I just grabbed my head and I just screamed and stomped my feet. And I'd really start trying to get the alcohol out of my ear, and she would be slapping me and pulling my hair. And I'd get up to go out, and one time, there was many times, one time I turned around and I looked and there was another girl. She came in after me and she sat down, and Sister Joseph pulled her head over and started pouring that. And I was watching her and she did the same thing. She was just really pushing her on her ear and screaming. And I was watching because I was thinking maybe it wasn't supposed to hurt. Maybe it was me. Maybe it wasn't supposed to hurt anybody. And in grade 6, Miss Bojme, she went over and she really sharpened her pencils, really sharp, and she walked over to where I was sitting and she just stabbed me right here. And she broke her pencil, and she kept telling me, right, and told me that I was being punished. And I still have that lead in my shoulder today. I lost hearing in my right ear. And when they operated, they cut it and they tried to fix it. And I was gone away in this Indian hospital in Sardis, called Sardis. And my mom didn't know where I was. I was gone for a whole year. And when I came back, that's what Miss Bojme did to me. And then I went to be a senior, and Sister Anne Rosario just seemed like she was strapping me all the time. Like she would strap me with all the girls with a really long leather strap that you sharpened shaving blades for shaving, men's shaving. And she would come up over her head, and then she would come down on our arms, and we had to kneel in front of her with both of our arms out. And sometimes my hands and my arms would be swollen and aching, and I'd try to go in the bathroom and soak them in a sink with cold water. But she'd come behind me and she'd hit my head on the sink and tell me, get out. Sister Juliet, when I was a little girl, she was in juniors, and one time I was saying "tlak, tlak" in Indian in my own language, and we're trying to say coming, coming. She came over and she told me to stick my tongue out, and pulled my head back, and I stuck my tongue out, and she came an upper punch under my chin, and I really bit my tongue, and she said, that's a devil's language. You don't use out language. You're going to go to hell. You have to obey. And then I was eyewitness to sexual abuse. There was this garage that wasn't very far from the building, and I heard some noise in there, so I snuck over there, and I was peeking in there. And the priest was in there with a girl, and he had his private parts in her mouth, and he had her hair pulled down, and she was kneeling in front of him. And the same girl used to pee her bed all the time, and the nuns would tie her hands and her feet to her bed and ridicule her and have the other girls laugh at her. And she ended up with a really bad arm. Like, they used a needle on her. When they'd give us needles, they used the same needle on her, and she ended up with this really big sore on her arm, and it just kept getting bigger and bigger, and you could see the bone. And she used to walk around, and you could smell it. And she's the girl that used to pee the bed all the time, and she had a nervous breakdown. And right to today, she is very afraid to get the COVID vaccine. There were some girls that tried to run away, but they were made examples of. They were really brutalized. They got their heads shaved bald, and they were beaten. And we had these lockers with our numbers on it, and they were rectangular lockers. And those girls used to try to crawl in there, like they tried to squeeze in there and hide, because they really were being brutalized and ridiculed. There were no doctors, there were no nurses for any kind of anything like illness or anything over there. There was no nutrition. Our food was, at times it smelled like the porridge was rotten, like they had rotten meat in there. There was meat in our porridge, and they used to have prunes, those rotten prunes in our porridge. But if we didn't eat it, they would give it to us for lunch. This was every day for 7 years, and much, much more. This is just the tip of the iceberg. The Canadian state statutory laws and Christianity, they forcibly removed children from their families and their communities. Again, this testimony from myself, and a survivor of residential school or prison. This is only minimal of what my people have experienced and were subjected to in these prisons. There were numbers, no names. The Canadian state perpetuates its image to the world that they are a leader in human rights, a leader in reconciliation. They want global security and prosperity, a more just, inclusive, and sustainable world. Indigenous grassroots people know this is false and their lies. The Canadian state in its jurisprudence subscribes to the doctrine of discovery, the people bull, the domination and the dehumanization of Indigenous peoples and children. I realize and I know that there are brave and strong rapporteurs that report and make recommendations based on fact. We give you inner strength, to do what you see is right, based on what you see, based on determination, assimilation, and genocide of Indigenous people, based on fact. Indigenous peoples, citizens, and intergenerational survivors of these Indian residential school prisons to call on Canada to take action and repeal and revoke the doctrine of discovery, the Papal Bulls of 1452. I encourage the United Nations to act with genuine results. This intergenerational genocide we are still suffering with We had nowhere else to go for help. The United Nations can request a Canadian state delegation of Indian school, Indian residential school prisons, survivors of torture, degradation, termination, genocide, to testify before the United Nations Human Rights Tribunal. Gochjam, Goseltens, Gochjam.
I would like to thank you very much for your statement. It is a very riveting statement, of course. Of when Alaska in 1955, this is an important part of the presentation that she is giving, because in 1955, Teton v. United States of America, Alfred Rochi, during the last days of his term as an independent expert on the promotion of a democratic and equitable international order, he did a memo. And in this memo, I'll read you the paragraph, and I'll show you how this ties to the Canadian Indigenous peoples, to all the Indigenous peoples of North America. And here's the paragraph from this memo. The United States Supreme Court instituted doctrines of superiority and racial discrimination in law and policy by the Teton v. United States of America, 348 U.S. 272, 1955, making it clear in footnote 18, and here's the quote: this purpose and acquisition and its effect on land held by the natives, in parentheses, of the Philippines, because this was quoting a Philippine case, was distinguished from the settlement of the white race in the United States, where the dominant purpose of the whites in America was to occupy the land, unquote. Further, the Teton judgment relies on the precedent of the Johnson v. McIntosh 21 8 week 543 1823 case, which held that the character and religion of the native inhabitants of America justified, and here's a quote from the case, considering them as a people over whom the superior genius of Europe might claim an ascendancy, unquote. The denial of the right of self-determination on grounds of racial discrimination and the application of doctrines of superiority constitutes a crime against humanity tantamount to a form of apartheid. Why is this important to Canada also? Because the 1888 St. Catherine Mills v. the Queen case used the precedent of the 1823 Johnson v. McIntosh case to say that even the Indigenous peoples of Canada had to adhere to the ascendancy of the European civilization. They were better than us. Therefore, they could do what they want with us. One thing that she said in her talk was that this was done based on statutory law, the 1951 Indian Claims Act. The Catholic and other church schools worked in concert with the state, and the mounted police went and took these children and brought them to the school. This was the intent to destroy in whole or in part a racial, linguistic, etc., as it's stated in the Genocide Convention. So what we're looking at is a very serious charge of genocide against the Indigenous peoples, children of Canada, who are defenseless. And there's much more to this, but I'll let Alfred say something. But this is just the tip of the iceberg, as she said. And the Indian Claims Commission or any residential school commission should not serve, because when they were doing this residential school commission in the newspapers, it was very clear. The church, the state were concealing documents, destroying documents. If there's a genocide case against others, why cannot it be the same when it's against indigenous peoples? And I like to quote Ward Churchill from his book, Indians Are Us, because Robert Jackson, who was a chief prosecutor in the Nuremberg tribunals for the United States and for the states that defeated the Axis powers, said this before they executed Julius Streicher: if we don't live up to the same standard, then we just murdered Julius Streicher. So we can see there's a double standard here again. And what could we do about it? I'll give you the floor, then we need to move on.
Sure. Very quickly, just to no, very quickly, referring to this book, which I recently reviewed. It is a doctoral dissertation by Tamara Starr Blanket, also an indigenous from Canada. The title is Suffer the Little Children, Genocide, Indigenous Nations, and the Canadian State. So this is a dissertation in law. So she actually goes in detail into the criteria of the Genocide Convention of 1948 and how that reflects on the experience of the indigenous of Canada and of the indigenous of the United States. In Canada, there is now a movement called Idle No More. And I was thinking that it is time that in the United States, there be a movement, Indigenous Lives Matter. Because what most people don't know, and it is not in many history books, although all the data is available, there used to be 10 million indigenous in North America, in the territory which is now United States and Canada. At the end of the 19th century, there were barely 190,000. And back in 1970, I hitchhiked from New York to California and back. And the one thing that struck me then is that there were literally tens of thousands of names of villages and towns and cities and rivers and lakes and mountains. And they all had indigenous names. And you asked yourself, what happened to all of these people? Well, there was Wounded Knee, there was Sandy Creek, and there are countless others.
Okay, thank you, Alfred. We'll move on to the next speaker. And the next speaker is John N. Shipton. Shipton, he is the father of and defender of Julian Assange, and he will appear in a video. And I asked him to give me his biography, and he just said simple. I have 2 words. I'm building industry. That's what he did during his lifetime. So, but to give you just a little bit more, he spends his time now traveling Australia, the United States of America, and other places. And he does come to Europe to talk too, as a defender, talking about how in the Assange case, there's underlying danger and concerns of freedom of expression and freedom of press in today's world. But we just start now the video of John Shipton.
Dear friends, Julian Assange, journalist, publisher, moves towards the 12th year of arbitrary detention and jail. innocent of crime and extradition refused, in Belmarsh maximum security prison. The mid-20th century great civil artifacts, the United Nations, the Conventions of Asylum, Universal Declaration of Human Rights, the Council of Europe, and embrace in national legislation of human rights, all move towards ruin. What rough beast slouches towards Bethlehem to be born? The singular icon, example of state despair and cynicism, is Julian Assange's persecution, characterized accurately as a deluge of malice over a period now 12 years. The Conventions of Asylum trampled, declaration by United Nations Working Group on Arbitrary Detention derided, due process trashed, malfeasance and misfeasance documented, entered into by the United Kingdom Prosecuting Service and the Swedish Prosecuting Authority. Professor of Law at Glasgow University and United Nations Rapporteur on Torture, Nils Melzer's exacting review revealing Julian a victim of deliberate psychological torture over these years, characterized as, before our eyes, slow motion murder. Nation states' despair, misuse and cynicism towards the 20th century's attainments, magnificent civil artifacts bound within the United Nations, has led to 20 years replete with a ceaseless barbarity. Our noble task, my noble task, to free Julian Assange and acknowledge and recreate the prestige and deliberations of a truly magnificent civil structure, the United Nations. Thank you.
Okay, thank you, Mr. Shipton, for your contribution. It's very important, and we laud you for your efforts to bring light to one of the most famous whistleblowers and the one who brings to the forefront the challenges we face today of freedom of expression, freedom of the press. And to ensure that we are finished on time, I'm going to go straight to Dr. Vikki Casanova Willis, PhD. She is the co-executive director of the U.S. Human Rights Network, a national network of over 300 organizations plus individuals working to strengthen a human rights movement and culture within the United States. She has worked with the West Side Justice Center Board and is past president of National Conference of Black Lawyers. And Dr. Casanova Willis is an educator and administrator and is a founding member of other organizations. She's testified at national and international forums, co-authoring several UPR, CERD, CAT stakeholder reports, and co-hosted the working group of experts on people of African descent. She also works with the International Human Rights Association of American Minorities and continues to promote human rights for peoples in the United States of America. So I present to you Dr. Casanova Willis.
Greetings, peace and blessings. I look forward to the video stream.
What about the people, the other side of the human rights equation? Greetings, I'm Dr. Vikki Casanova Willis, co-executive director of the U.S. Human Rights Network, paying homage to the ancestors, those who came before us and on whose shoulders we stand, urging unity for the generations living today in the current struggle for truth and justice, and thinking of future generations yet unborn to whom we owe our best efforts to leave a legacy that will redeem and repair all that we can, that they might inherit a planet and a future that are better because we made the promise of human rights for all peoples a reality while there was still time. The U.S. Human Rights Network is a national network of 300 plus organizations and thousands of individuals since our founding in 2003, working to strengthen a human rights movement and culture within the United States, led by the people most directly impacted by human rights violations. We work to secure dignity and justice for all on a continent built on stolen land, by stolen lives and labor of those who to this day are not treated as full humans. We have learned firsthand that the promise of human rights is aspirational yet achievable. The challenges, however, are daunting and with multiple elephants in the room. The myth of white supremacy and the corrupting influence of unchecked greed have an apparent stranglehold on sanity for the powerful, moneyed, and even those in positions of influence whose hearts may be in the right place at times. What do the people on the ground have to say about living in a global and domestic society that uplifts the language of human rights, but is struggling to walk the talk? The denial of justice for people of color and others at the margins is deeply entrenched and seemingly insurmountable, even at times in the UN system. And as US civil society shared with the Biden-Harris administration last week, without a national human rights plan and infrastructure, and our federal, state, and local governments ensuring accountability, efforts remain symbolic at best. 2020 took the blatant disregard for life to a new low and looked us straight in the eye while we watched modern day lynching play out in real time for the world to see. Still, far too many are immune to state violence against Black people, and we contrast the response to events of January 6th. Double standard indeed. So the time has passed for further analysis. It is action and accountability time now. We seek transparent, early, and equitable participation of civil society in matters affecting people's lives, livelihood, dignity, and very existence. We need a human rights framework with integrity because civil rights is not enough. In a country whose civil code still authorizes legal slavery in the prison system today, human rights is clearly not on the agenda. Where is the justice in a criminal punishment system that incarcerates more people than any other nation on the planet? And it's well known that the masses incarcerated in cages for most of their lives are overwhelmingly African descended, followed by Latinx and indigenous peoples. Where is the moral authority for a nation that has ripped families apart for more than 400 years and continues to this day, separating parents and babies at its southern borders and in its airports from melanin-banned countries and on city streets and neighborhoods daily across this nation, filling the jails and detention centers legally, civil law? And what about the children? In my country, the only one to still resist ratifying the Convention on the Rights of the Child, one must assume the honest answer is, who cares? The global community can and must do better with regard to human rights accountability, even when there are just decisions made, either in the US court system or through strong recommendations from the UN. Implementation has not been a priority. It's been a challenge. The American exceptionalism, which could manifest in pride and a commitment to uphold the highest standards of our Constitution and the treaties we have ratified, instead allows a blatant disregard for human rights remedies. This continues because those who benefit from the power imbalance have no regard for the grave cost we all pay, ultimately, for denying the very humanity of other living beings. Human rights cannot mean perfecting the form while neglecting any substance. What about the people? The UN Human Rights Council, or HRC, is the international intergovernmental body for promoting and protecting human rights worldwide. 1 year ago, in response to demands from families and allies of those murdered in cold blood by state violence, Amid the US Black Lives Matter movement that lit a spark around the world, the HRC convened an urgent debate to address current racially inspired human rights violations, they said systemic racism, police violence, and violence against peaceful protests. Historic and significant, but it was a compromise. The late George Floyd's brother, Willis, and hundreds of other directly impacted families and ally organizations we helped anchor had urged the council to establish an independent international commission of inquiry focused on the ongoing human rights violations by law enforcement in the US. Instead, they adopted a watered down resolution due to diplomatic pressure from the United States government. Thus, despite achieving an unprecedented acknowledgement of systemic anti-Black racism and a new potential for greater accountability, it was nevertheless a compromise. HRC Resolution 43/1 mandates the High Commissioner to prepare a report on human rights violations against Africans and people of African descent by law enforcement globally and on the government's responses to related protests. A first. But the jury is still out. The people await the High Commissioner's report due this month. Then what? Time will tell. Ultimately, justice can only be achieved with collaboration from the international human rights community. It will require a shift by those in positions of power and privilege. We, the network, stand with our allies and members of all ages, races, abilities, genders, and access because we understand that our destinies are intricately intertwined and that we must not lose this chance to courageously challenge the status quo. As we look toward overcoming the lasting legacy of chattel slavery that funded this very system of oppression that we seek to dismantle, the decade is winding down and much remains to be done. One urgent task is human rights education, which will be crucial to shift the paradigm. When the mass media and school curricula elevate one culture at the expense of all others, that false narrative becomes the reality and strengthens systemic and structural racism. Denying people of color the right to culture and educational content that earns their humanity is criminal. And it reinforces a false deficit-based stereotype, dehumanization. Per the Universal Declaration of Human Rights, Article 26 and the SDGs, number 4, we have a human right to education, fully inclusive, respectful curriculum, educators who value all peoples and cultures, equity and resources and access, and it must include human rights to be a quality education. Social media exposes the lethal effects of propaganda and miseducation, fueling a climate where endless war is acceptable and Black lives from the US to Brazil to Colombia do not matter. This double standard must end, and it will take all of us. Human rights defenders and enforcers must unite as a principled coalition against oppression. Speaking out must not be allowed to generate backlash and brutalization based on differences which are only skin deep. The targeting of current activists and journalists echoes the COINTELPRO political prisoners' plight, dying after decades in prison, elderly and infirm. Those were the Black Lives Matter youth of their 60s civil rights era. We must face facts. White privilege and the myth of white supremacy wield a powerful and destructive influence too often. The human rights movement must be decolonized, or the UN will fall far short of its full potential. To continue accepting anything less is hypocritical, deeply, for all of us. The way forward will require courage, truth, justice, reparation, and transformation. The U.S. Human Rights Network urges unity to hasten towards full cooperation and embrace of a new paradigm, a process of finally walking the talk of human rights. The world and all its precious peoples truly cannot wait any longer. Asante Sana.
Hi, and thank you for inviting.
So that is a very good discussion that you just gave, mentioning human rights defenders. And it brought to mind justice can be achieved only when there's the desire to pursue it. And collectively as peoples, as civil society, as states, as nations and peoples, we have to remind ourselves that there's many good people in every country, and I've seen this. There's lots of good people in Europe, in the United States, in Africa, in the Eastern countries, Russia, and you meet very good peoples from all over the world. But it's us who must pursue this. States have the responsibility to uphold it, but we must push these states. Sometimes we work against NGOs who are put or installed by the Secret Service of particular countries. And sometimes we have NGOs who deliberately work against us because, and I've faced them, I've been threatened by them. They're good church-going NGOs who give you death threats. I received one in the Palliative Nations. So when we talk about NGOs, we have those of us who are trying to pursue, to promote, protect, to call on everyone to abide by human rights. So with that, I'm gonna go right to our next speaker, my good friend and brother, Barrister Majid Trambu, who will be speaking from London. He is a renowned human rights and humanitarian lawyer of more than 40 years experience. His distinguished legal career began in 1983 at his birthplace in Kashmir. As a recognized and leading expert in public law, he is committed to work for fundamental freedoms, providing assistance to people within the EU and the UN framework. He's defended people in the WHO, in WIPO, employees, etc. He is founder of a law firm in England and Wales known as MTUK Solicitors, and a director of International Human Rights Association of American Minorities, which is co-sponsoring this event. So I present to you my friend, my brother, and he's the permanent representative of IRAM for his presentation.
Thank you very much, Ambassador Barnes. Greetings to all of you who are listening to me. And I see many of my associates on the panel. I particularly would, of course, remember our great friend of humanity, Professor Alfred Rochi. I hope he is hearing me. And of course, Marianne Mills, I'm seeing. It's very nice to see her. I did say Leon earlier on, and Professor Ronca is there. Joseph Ronca is there as well. Very, very great to see all of you. And of course, there were very much formidable presentations on the double standards in human rights. And that's where I will stick to be quite honest. In my view, moving the human rights agenda forward during this century to the next century requires promotion of social and economic environment, which I do not see at the moment, to be quite honest. And then if we promote social and economic environment that will be conducive to respect for human dignity. And that is what we are lacking at the moment. Indeed, as we see, we are living in a complex world. And particularly now, COVID-19 has made it much more difficult, where human rights, social justice, and economic betterment are politicized. And I would even go to the extent to say is weaponized. Without any question, decisions are made and enforced depending on the political will of the states, parties of the United Nations. And undoubtedly, there are double standards on human rights. The countries of the West and their allies across the globe continue to create an inherent imbalance in the promotion and protection of human rights. But it's not limited only to the West. I must say It's applicable to all the 5 continents of the world. But it is very much evident in my view that what I have seen over the last 4 decades, that human rights are determined at WTO, World Trade Organization. And that leads corporates, military, and renegades, activities of some of the world's powerful countries to violate the territorial integrity, the right to development, and above all, right to self-determination. World peace and development is the key for the progression of human race. My very dear friend, Alfred Rochi, in his report to the General Assembly, numbered A/68/284, which he presented on 7th August 2013 to the General Assembly, at a very famous paragraph 69N, eloquently stated, and I will quote Alfred here: the General Assembly may reconsider revisiting the reality of self-determination in today's world and refer to the Special Committee on Decolonization or other United Nations instances, communications by indigenous or unrepresented peoples wherever they reside, inter alia, in Alaska, Australia, Canada, Chile, China, the Dakotas, French Polynesia, Hawaii, Kashmir, the Middle East, New Caledonia, etc., etc. All these countries and peoples who are unrepresented and nations who are not recognized, he referred to, if you want really the world peace. That is a factual situation, to be quite honest. If you want human rights to be across the board and across the world, then you got to recognize the significance and importance of self-determination. Now, in my view, there are 3 suggestions which I propose in the direction of human dignity to combat double standards in human rights. First, and I would again say this is something very crucial, reforming of the United Nations, I believe, is very crucial all round. The need for voting reform in the General Assembly, the possibility of weight voting system, increasing membership of the Security Council on regional basis, and eliminating the veto power. Again, our great friend, in his report, which I quoted just now, vetoing privilege, what he says is, Alfred Rochi, Professor Alfred Rochi, an obvious obstacle to a democratic and equitable order in the use and abuse of the veto privilege in the Security Council. To any neutral observer, the record of veto practice over 6 decades demonstrates that it has often been used inconsistently with the purpose and principles of the Charter, notably against the right of self-determination and to block sanctions against or mere condemnation of countries and situations that violate United Nations principles. The abuse of the veto power has become so predictable that frequently resolutions are not even tabled because of the certainty of a veto against their adoption. Necessary discussion is thereby suppressed. Concerted action by Security Council, the General Assembly, and other United Nations agencies is necessary to prevent major human rights violations, stop ongoing breaches, and provide remedies to victims. That is the situation with regard to the Security Council veto. Second, which I feel is very important, is creating and electing World Parliamentary Assembly of civil society. It has to be civil society-based representatives. And third, whatever systems we have, whatever human rights mechanism we have, strengthening and improving human rights mechanism, including not only strengthening those, but including its enforcement mechanism all around. These are something very, very crucial things that I believe should be taken in order to combat the very much double standards in human rights. And there are, world scene is there where you can categorically identify and recognize where the double standards are. It's in my own state, which is known as the state of Jammu and Kashmir. India, being economically very powerful country, blocks everything at the Security Council. We have the Security Council resolutions for self-determination on Jammu and Kashmir. Well, more than 74 years old resolutions. In fact, earlier on, Alfred Rochi said under the UN Charter, which is the constitution of the world, you have if there is a Security Council resolution, it's enforceable. But our resolutions have not been enforced till today. That's where the double standards are. That's what we have to work for to eliminate. Thank you very much, Ambassador Ronald Barnes.
Thank you, Barrister Majid Trambo, and thank you for your presentation. It's very good. I'm going to move right away to Jacques Baud, and he's one of our 6 or 7 main speakers, and after we will open the floor, but then we will see if some press have questions. Jacques Baud holds a master's degree in econometrics and postgrad diploma in international security from the Graduate Institute of International Relations in Geneva. I'm going to just paraphrase. He's worked for the Swiss Armed Forces. He worked for the UN Department of Peacekeeping Operations. He's a worked with the UN expert group on security, sector reform, and the rule of law. He's worked in NATO and is the author of several books on intelligence, asymmetric warfare, terrorism, and disinformation. We live in a world of disinformation today where we have to decipher what's real, what's true, and how we address all this. So I give you right away, Mr. Jacques Baud.
Thank you very much. You hear me? Everything is fine? Okay. Thank you very much for inviting me to this discussion. I would like to come back. I see that you're showing my book. That's a Ruling by Fake News, which is a book that I published last year. And to be complete, I'm publishing today a book on the Navalny affair. And next month, I publish another book on the Protasevich, the Belarus hijacking incident. The whole thing about these books are not so much to talk about the incidents themselves, but to come back to something Alfred Rochi pointed out previously, which is, in fact, the fact that we just give up applying the rule of law. And everything you mentioned in this discussion before can be human rights, it can be a right of self-determination. Everything, in fact, comes back to the application of the rule of law at national, but also at multilateral level. Now, it's interesting that all the issues that we see today and all the problems that we are witnessing almost every day with involving Russia, China, Iran, the United States, and so on. All of them come, in fact, from challenges that the US are facing because of the lack or inadequate or failed strategies. The lack of investments in domestic infrastructure, in education, in technological innovation, the focus on expensive foreign intervention rather than on domestic development has led to a slow decay in US leadership in many areas. As a result, and that was acknowledged by Joe Biden last March, as he said, the rest of the world is closing in and closing in fast. We can't allow this to continue. And that explains all. As his predecessor, in fact, he realized that the US is no longer in a position to compete with its main challengers in the long run. And that explains the US efforts to put China, Russia, and other countries under constant pressure. This is a strategy that has been described in a paper published in 2019 by the RAND Corporation entitled Overextending and Unbalancing Russia. And that explains how you can maintain pressure on countries just by using false narrative to discredit them and using various issues such as human rights, economics, different issues to maintain the pressure and to trying to disconnect them from the international community. It's not new, in fact, that we create a false narrative to discredit an adversary. What is new, however, is that the false narrative becomes the rationale for shaping foreign policy decisions that translate quickly into sanctions, embargoes, and other punitive measures, thus bypassing the traditional way of settling disputes through diplomatic processes. The problem with that is not so much the why and the what we are doing. The real problem is the how, because we tend to take our assumptions as facts. And this raises a variety of issues. Let me just discuss a few of them. The first one is the sincerity and the credibility of Western leadership in complying with the rule of law. Ironically, the Democracy Perception Index that was recently published by a German institute showed that 73% of Chinese people feel their country is democratic, while only 50% feel that way in the US and in France. And that's a quite interesting observation, because that shows that, in fact, our democratic governments are no longer really credible. And if you think about it, the main difference between autocratic regimes and rule of law based regime is the way decisions are made and monitored through democratic processes. The main purpose of rule of law is to keep political decision making based on facts and rationality, and to avoid or limit arbitrary or discretionary decisions. And there is a variety of tools to achieve that. One of them, of course, is in each country, the intelligence community. And that leads me to the second issue. It's important to me because I was a former strategic intelligence officer. And I always considered that the intelligence services in a country is a tool for the rule of law, in the sense that it should help government to make rational decisions based on facts and not on perception of facts. In fact, the ability of an intelligence service is to advise and to understand the situation as it is and not as one can perceive it. A functioning intelligence apparatus produces intelligence rather than information. Intelligence comes from the Latin verb intellegere, which means to understand. In other words, intelligence should help decision makers to understand the situation and not to influence them. And if a wrong decision is taken, then there are two possibilities. The first one is that the intelligence was not able to understand the situation properly or to gather the facts to interpret them properly. The second possibility is that the decision maker doesn't listen to its intelligence service or doesn't take them into account to make decisions. In the last couple of years, we have witnessed many accusations against Russia, China, and others that our governments were never able to substantiate or to provide any evidence for. In most cases, they even rejected any offer for judicial cooperation or requests to share information. That was the case for Skripal in England in 2018 and in Navalny last year. The third issue relates to the political decision-making process in the West in general. How can we make decisions that affect entire population without having a solid understanding of the situation on the ground? A recent example of Navalny poisoning or the recent Ryanair incident in Belarus are cases where the Western politicians made statements and asked for sanctions within minutes after the events, based on tweets and without having any solid knowledge of the real facts. And that's an extremely disturbing development that is not limited to foreign policy. The coronavirus crisis also shows that our government tend to adjust the facts to the policies instead of adjusting the policies to the facts. At the end of the day, we can only observe that nobody seems to be interested in improving the rule of law or human rights. As stated in a memo addressed to Rex Tillerson, as he was Secretary of State in May 2017, we are just using these issues to weaken our adversary, not to improve the situation of the population. And that's why even supporting the support to extreme right-wing groups or jihadist group for the sake of weakening a government is in fact accepted. So Western values have become a convenient way to conceal more opportunistic and less honorable goals. In the early 90s, globalization was understood as a way to promote prosperity and enhance the rule of law and democracy through cooperation. Whether or not this strategy was realistic is debatable, but today this aim has certainly been forgotten. The name of the game is no longer to improve and elevate ourselves, but to weaken others. In fact, the logic has been reversed because major actors have a selfish, ethnocentric understanding of international relations. And the problem is that if we look back at the 1930s, we can probably notice that unfortunately history tends to repeat itself. Thank you.
I would like to thank you, Jacques Baude. It was good to meet you over the phone, of course, and to hear you speak. Right away, I'm going to go right to our administrator over here and ask if there's any questions from the press. Okay, there's one question, and I would like to repeat that. Could you say it? Okay, he will ask it. Okay, it's Mr. Yuri. Oh, do you have a question? Tobias, you said it's a member of the press? Okay. Okay, we'll go back after. Is there somebody from the floor here who would like to give a quick intervention or a question? Okay, if not, then I see perhaps Marianne Mills or Leon Siu, if you would like to make a short statement and a question. Start with you, Marianne.
Thank you, Ron. Shashida Nikutichi Shiishi Katnutana Yahunan Eshlan Yishtu. My name is Marianne Mills, and I am a citizen of the Kanaitsi Indian tribe. I have walked this earth 75 years and have witnessed and have been a part of Alaskan history. If I offend, I apologize, as my intention is to share knowledge and experience. I consulted with other elders, and many shared the same concerns and thought. Martin Luther King stated, "Our nation was born in genocide. We are perhaps the only nation which tried as a matter of national policy to wipe out its indigenous populations. Moreover, we elevated that tragic experience into a noble crusade. Indeed, even today, we have not permitted ourselves to reject or feel remorse for this shameful episode. This genocide has never ended, leaving a path of systemic racism that has touched people of color here within the United States as recent as today. As a child, I recognized these shortcomings. As I grew up, I was fascinated by the sacredness of people like Crazy Horse, Mahatma Gandhi, Martin Luther King Jr., and many others. I prayed their visions of a just and peaceful nation and world would evolve. During my 50 years of advocating for Alaska Native peoples, I have witnessed violence against Natives getting worse. We have among the highest rates of violence against women, missing and murdered women, and sex trafficking. Our suicide rate is the highest in the nation, which proves that one does not need bullets to kill a race of peoples. Social engineering works just as well. In the United States, Alaska Natives and American Indians are incarcerated at a rate higher than Black Americans. We rank on top for almost every ugly statistic there is in the nation. We are the invisible peoples. Ernest Greening, who was the first governor of Alaska and a U.S. senator, describing Alaska, stated, "I had found that the pure democracy and egalitarianism of Alaskans, which had so impressed me, was subject to one exception. It did not apply to Alaska Native peoples, Indians, Eskimos, and Aleuts. Colonization through social engineering in Alaska has created traumas that are so despicable that Dr. Robert Albert, psychiatrist in private practice and a member of the Advisory Council of the Alaska Native Foundation, stated that Alaska Natives suffer the same symptoms as prisoner of war victims. Our survival is based on the truth. The truth is that we, along with other Alaskan Indigenous peoples, have the right to nationhood, not only by the United States Constitution, but by international treaty and law. The truth is that our presence in our homeland is both offensive and bothersome to the United States, and our right to equal justice under law has not been honored. For this reason, Alaska needs to be placed back on the list of non-self-governing territories under the United Nations General Assembly Resolution 66I. The Alaskan Indigenous peoples has demonstrated its political will through the Alaska Intertribal Council Resolution 2005-10, as well as a resolution passed at the National Congress of American Indians. Free us so we can become self-determined and thrive. Thank you.
Okay, thank you, Marianne. Just a second. I don't know if anyone else would like a question, perhaps Leon, for 1 minute, because I am being told that we must start closing up. Go ahead, Leon. I don't think we could hear him.
Okay. Yes. Aloha. Aloha ia mai o ko ai maluhia hoi kia kua. And greetings to everybody. Mahalo for having. Thank you very much for having this discussion. It has been very enlightening and also, in a way, also very how would you say sobering, because we do have you know, all of the presenters are very, very excellent in what they presented, and it brings us to the realization that what we're looking at is this double standard. That it's not only a double standard; it's systemic. It's systemic to the system. And so, are we actually being realistic in expecting the system itself to reform and to pay attention to what we are saying? And so I think sometimes, you know, I get frustrated myself with the fact that all the facts are presented and all of the arguments are made, and the rule of law is on our side, and yet there's no action. And so we need to somehow transform the systemic functions of the United Nations as well as other international organizations to begin to do things in a different way. And so this is, I think, our biggest challenge is the entrenched European civilization's way of doing things and not actually being open to anything else. So this is our challenge, and this is something that we in Hawaii realize, and we are really trying to work at finding ways in which we can actually convince the world, and particularly the United Nations, to function in a different mode, in a way that actually pays attention to the rule of law, to the rights of people, human rights, civil rights, and all these things. So I appreciate the discussion, and I think that this also just emphasizes the fact that we have quite a ways to go to change the system itself, or perhaps present a whole new paradigm and a whole new system of how we would do things. So mahalo nui, aloha.
Okay, thank you, Leon. He was our final speaker. I don't think anyone in the audience has anything to say. What I would like to say is Leon is the foreign minister of Hawaii, and like Alaska, as experts like the late Ian Brownlee stated, you need to assert your rights, whether recognized or not. You assert your diplomatic status. You assert your right to self-determination. I've done this sometimes where the chair would pick up and almost or sometimes call me out of order. I've been one of those who have taken the chance to call a point of order. Why? Because as Indigenous peoples who are recognized equal to European nations, and that's how the US said it when Russia tried to claim Alaska, and a UN report came out saying the 1867 treaty granted neither title of Alaska or jurisdiction to the United States. Why? Russia had nothing to grant. They did not acquire it. So we try to move, and we ask in a very, you might say, nice way to European states, to all other states, states of the South, to come together to address some of these very egregious human rights violations, and hope that we can move toward making this world a better place. It's an aspiration, of course, from the Universal Declaration of Human Rights. And of course, there's a Human Rights Covenant, the Charter itself, which I'm not afraid to assert our status, and me as a diplomat with diplomatic powers. At the same time, I need to be practical when I walk into the United Nations, because really I'm only accredited as an NGO, and it's only because some states would raise their hand and say something that maybe we would get away with something. So now we have, besides a closing statement, one of our organizers here who would like to say something and see if anyone else has any more questions.
Thank you very much, Mr. Barnes, for this interesting conclusions. I guess if there is no question in the room, we will have absolutely to wrap up now. I thank you for being here. Thank you to our speakers here, to Mr. Barnes, to Mr. Azayas, for your interesting positions and explanations about this question of double standards, as you have said to it. So, and thank you to everybody. And so I close this session now, and see you perhaps again soon. Bye-bye. Thank you.